Yeah, so you have Mr. Balian plus defense counsel plus...
Yes, everybody's here, Your Honor, and I believe at some point Mr. Lewis may have to sign off, and I'll appear for him. It's Mr. Chestnut.
Thank you. All right, we were discussing the issue of remote testimony, and the proposal from Mr. Lewin is to use 1340 of the Penal Code as a model. 1340 ordinarily allows remote testimony in the context of conditional examinations, but it is a model. And the authority would come from California Code of Civil Procedure, Section 187, and People versus Lujan, 211 Cal. 4th, 1499. And let me ask, Mr. Lewin, my question is, why do you specify age 60? The CDC guidelines regarding COVID-19 specify age 65 or older, and that's the scenario we're dealing with. Why do you say 60?
You know, I believe at the time when I wrote it, Your Honor, as the court remembers, what happened is this motion was filed originally under seal, the first version. Oh, okay, I'm sorry. Can you hear me now? Is that better?
Much better.
Okay.
Much better.
So, originally filed it was filed under seal because we didn't want to panic, you know, jurors and other witnesses, etc. And at that time, Your Honor, they were saying that witnesses over 60, individuals over 60 had a much greater health risk than those below 60. That's why we chose 60. Just so it's clear, I don't think, in terms of our out-of-state witnesses, I think almost everybody is over 65. There might be a few that are between 60 and 65, but I still think, Your Honor, that given the situation with having to travel through 2 international airports, everybody is coming from New York, New Jersey, etc., Boston. I don't have the list in front of me, but in essence, people are having to travel through very large airports, at least 2, that the rationale would still apply. That the bigger issue would go towards primary versus non-primary, and it's the people's position that given the orders by the Chief Justice, that the court would be able to say, and I'll give an example, Your Honor. Douglas Durst would likely be, the defense would probably call him a primary witness. We would probably say, you know, in terms of what Mr. Durst is actually on trial for, he's not primary, but you could certainly make the argument that he is substantially more primary than, say, Kathie's classmates. However, when you start balancing the idea of what is the risk-benefit of the witnesses testifying remotely versus having to fly out here, and again, to go back to something Mr. Chesnoff said, is one of the advantages of the witnesses testifying remotely by camera is they will have their masks off. People will be able to see their whole face if they're testifying remotely. The jury can see their expressions.
We may well do something like that because we have the sneeze guard, we do have the shield up, that we may be able to do something like witnesses at least revealing...
But that is the reason that we had said 60. And we do believe, Your Honor, that for the purposes of this motion, when you're looking at the protection of the public, we do think that 60 is a good balance. But I can't tell the court right now that there's a witness I can think of where the 60 versus 65 would make a difference.
Very well. So the questions I have are, first of all, does this procedure satisfy Maryland versus Craig's protection of the Sixth Amendment right to confront and cross-examine witnesses? Second, is there good cause to create a non-statutory procedure? And third, will you specify the witnesses and their circumstances? You've described only Dr. Helen Block, and I did have her circumstances as of March. I do not have current circumstances about Dr. Block. So if you would answer those questions within your argument, I'd appreciate it.
Okay, so we believe that absolutely, Your Honor, when you're looking at the constitutional protections, the Chief Justice, I think we have to presume that the Chief Justice of the California Supreme Court is well aware of what is constitutional and what is not constitutional. the orders that they have made, which have repeatedly emphasized the idea of using alternative means of having witnesses testify remotely, those are in several of the orders, give the court instruction and direction as to what the priorities are. Does the court wish any, and again, if you wanted to look at the issue of the constitutionality, if they have found a compelling societal interest in allowing a juvenile sex victim to testify remotely, I cannot see how you would not have at least as legitimate of a public safety issue with respect to the COVID situation, these witnesses as you would there. So I think that although COVID was not contemplated when they made this exception, it certainly fits within it. So that would be the first issue. The second issue, in terms of the specific witnesses that we are going to be calling, we made it very clear, Your Honor, that it only applies to witnesses who are out of state, that have to fly in. And that basically is going to be, I don't have the full list of witnesses, but in the end, Your Honor, their situations are going to be, in essence, the same with a few exceptions. So there are a few witnesses who are physicians who have some pre-existing health issues that make COVID even worse, the risk. However, it's the people's position that the court can say, utilizing 1340 and the Code of Civil Procedure, the court can say, listen, I am finding that given the instruction from the Cal Supreme Court, and given that I am to maintain the sanctity and the safety of these proceedings, that I am finding that whatever issue, whatever the defendant loses in his ability to have the witness directly in front of him, is outweighed by one, the danger of that witness, and two, that it can be effectively mitigated by having the witness in full view, in full screen, testifying live. The defendant will be able to see it, the attorneys will be able to see it.
Yeah, I'm gonna interrupt you for a second. This is the detailing, Your Honor. The people believe, based on the technology that's out there, there's actually no minimized confrontation involved. The defendant, as well as to see the witnesses fully cross-examine the witnesses. The only difference will be not being physically present in the same room. Thank you.
All right, thank you, Mr. Bailey. And so let me just, there's a kind of an underlying assumption you're making that I would make a rule for the trial as if it were a rule of court or a statute, that you would simply invoke this ruling when calling a witness. But when you look at Lujan, that was one witness, and the circumstances of that one witness were examined before the court agreed that a special procedure ought to be utilized. I believe that I must answer the question as to each witness rather than create a general rule.
Your Honor, may I ask the court this?
But Your Honor, this is Mr. Chesnoff. One other thing is, one of the big reasons for Lujan was the state's interest in protecting the child.
Thank you.
Along with the inquiry.
Yes, of course. Protecting the child is important, and protecting human life of all participants is important, and that's what we're trying to accomplish here. This is an unusual circumstance. The legislature did not exactly foresee it, and that's why long ago the state established a Code of Civil Procedure Section 187 so that a court might fashion rules to accomplish all of these objectives. It's in the interest of justice. And so I think that's a fair framework. So you may continue, Mr.
Thank you, Your Honor. So what I would suggest then, Your Honor, is when I leave court today, I will contact all of the witnesses that are out of state and over 60 years of age. With the court's permission, and I don't think I have any out-of-state witnesses now who are less than 60, but even if we do, I would think that it would be in the court's interest that I contact those witnesses. I say, listen, we're going to be starting up no earlier than July 27th. I need to explain to the court, are you willing to fly out here to testify? If you are not willing to fly out here to testify, and you believe that there are issues relating to your health where you need to testify remotely, I need you to please explain those reasons in a response, which I will furnish to the court. I will do that with each and every witness that's left. I'm not in the position to do that today because I did not know, and I've actually held off, Your Honor. I send these updates to the witnesses, but I've tried not to contact them when I don't have anything to tell them. So that would be my plan, but I'm pretty confident, and I guess I'd ask the court, Your Honor, is if what we get back, is the court willing to utilize this option for a witness who simply says, listen, I'm over 60, I don't have any pre-existing health issues, but I'm concerned about flying out here, cross-country, being in the airport, 2 different times, etc. And obviously, these people are going to have issues with, children they have and elderly relatives they have. In other words, how detailed do you want them to get? And I ask that simply because I think the court is well within its discretion to be able to say, listen, no one's disputing what the situation is with individuals getting on airplanes and flying out here and the risks that they take. And I am finding that since there's no minimization and no restriction of his confrontation rights, that I'm going to authorize this procedure. So I'll do whatever the court wants me to. I guess I'm looking for guidance. How would you like me to handle it?
Well, first I have to hear the defense argument. Hold on. The way this works is I asked Mr. Lewin to support his motion, and now Mr. Lewin has asked me a question, and it's premature. I obviously have to hear the argument of the defense as to whether or not this does satisfy Maryland versus Craig, if there is good cause to create this procedure given the pandemic. And there's a further question, and I've said this all along, I need to see the technology itself. I need to see for myself that indeed a lawyer, a juror can see the witness, hear the witness, and Mr. Bellion assures us that there's no sacrifice of confrontation. I want to see that demonstrated to me, and then the second part of your question is as to the showing required for a particular witness, and of course I believe I would need to hear objections from the defense as to a particular witness, whether or not that witness ought to be testifying remotely and for what reasons. I do think the CDC guidelines of persons 65 or older or with underlying conditions or both, I believe that I would find good cause in that instance, but again, they have specified 65, though you've chosen the number 60. So that's so before the defense argues, I want to hear the rest of your presentation, Mr. Lewin.
Yes, Your Honor. And with respect to the last, so what we will do, Your Honor, is assuming that the court preliminarily, and the court, Your Honor, my understanding is, and I think this is done on the record, the court had actually granted this motion previously.
The only caveat was I wanted to see the technology.
And so with respect to that, Your Honor, Mr. Milius is our expert on the technology. Can the court please incorporate, for the purposes of this motion, the email that Mr. Milius sent to the court and counsel describing
No, reproduce it, please. I mean, here we've been corresponding for our convenience, and I don't want to have, I'd ask you to do it that way.
There are two separate issues, though. The email was specifically addressed to communications amongst teams within a courtroom. This particular issue that we're talking about is communication on the record with a witness who's remote. So those are two separate things. Many of the same concepts that are at work, though.
Copy and paste, please.
I'm sorry, Your Honor, I didn't hear the court.
Copy and paste.
Okay, we'll do, Your Honor. So going forward then, we are prepared to give the court a demonstration when the court wants to have that done. So if the court, and that would involve Mr. Milius demonstrating to the court. We've done a lot of work on this. Zoom, when it's double passworded, is very secure. There are numerous things that have been done to make sure that this process remains confidential, but I don't think the court's not asking for the demonstration right now, correct, Your Honor? The court is asking for this demonstration.
Subject to passing the,
Yes.
the
And
test.
Your Honor, I would imagine that the court would prefer the demonstration in the actual courtroom that we're going to be using.
In Inglewood, yes.
So which kind of sets up, Your Honor, and just so the defense is ready for this. One of the problems that we're going to have is that I've got to arrange, transportation, etc., the logistics involved in getting witnesses out here. If we start July 27, it's not as if I can say, okay, our witnesses are ready to go, because we've got a lot of out-of-state witnesses starting July 28th. So my plan would be, subject to the court approving it, would be to do as I indicated. If the court preliminarily grants the motion today, I will contact each and every witness to find out what their position is in coming. I can tell the court, and I've already told counsel, just about every witness who's been out of state, this is no surprise, Your Honor, they're very apprehensive about coming here because of the issues that are involved. And I should also say, which I think demonstrates the sincerity of our position, is there are two witnesses who testified by conditional examination who live in Los Angeles, Linda Obst and Ricky Ring. And we have not at this point asked the court to find them unavailable, because in the end it would appear that even though they're both over 65, in balancing, there should be no reason why they can't come in here and testify with respect to social distancing, etc., because it will not involve travel out of state. So with the court's permission, Your Honor, that's all we would have now, other than if the court can let us know when Mr. Milius can go to Inglewood with the court. And obviously, the sooner we're able to do it, logistically, the easier it'll be kind of coordinating these witnesses so that we have a smooth restart of the trial.
All right, now let me hear from the defense.
All right, Your Honor, Dick DeGuerin. First, overall, we view this as a confrontation of an issue, of a constitutional issue that is not satisfied. As to the juvenile case, Lewin, it's not just a juvenile case, and the Supreme Court was very careful to point out that this is a very, very limited exception to personal confrontation. This was more or less, the witness was a pre-juvenile, a very young child, upon whom the personal appearance would have been very devastating to him, and there was plenty of evidence about that. So that's not, I don't think it's appropriate to draw a parallel between the exception drawn in Lewin to any exception drawn here for witnesses that have health issues. That as to the health issues, they remain, and they will still be here until we really get them all clear. I have maintained contact with my, just for my own statement, I've maintained contact with my cardiologist. I saw him last Thursday. I'm in good health relatively, but he says that I am very susceptible because of my underlying conditions to the COVID, and he says under no circumstances should I be at a point of contagion such as a courtroom or to travel. That applies to three of us in the defense as to age and underlying conditions. And so those health issues remain. there will be the same health issues that the witnesses have.
So what, so Mr. DeGuerin, explain to me, you're describing to me having underlying conditions, the difficulty of traveling, and now there are witnesses who are under the same circumstances. Therefore, how does that relate to whether or not I ought to allow remote testimony?
Well, because you're not going to be able to get the lawyers there. If the witnesses are under the same threat of health, we have the same threat as the witnesses do. And if you excuse the witnesses and allow them to appear remotely, that means that you should excuse the lawyers. But we can't try a case without being physically present. It just is not a substitute for the right of confrontation or the right of assistance of counsel. There is a danger to us, and the same danger that the prosecution is saying applies to the witnesses.
So I suppose what you're saying is that I'm going to reframe your argument. I guess your argument as to remote testimony is that when you return to the courtroom, they should return to the courtroom also.
Well, that's part of it, yes, sir. That's not the whole argument. I'm just saying that if you're going to excuse witnesses, you need to excuse the lawyers, and that means we don't go to trial yet. I don't know when. Everybody would have to speculate as to when the threat is going to be over. It's clear that the threat is growing. It's not getting any less. Houston is spiked terribly. And in fact, the headline in the Chronicle yesterday was that Houston may be the epicenter and have a higher incidence of coronavirus than any place else in the country.
So Mr. DeGuerin, you're just kind of getting...
Your Honor, it's Mr. Chesoff. May I speak for a moment?
Yeah, I'll say that he's echoing his earlier points and the points that you made, and I appreciate all of that. So
we're more concerned about the Zoom in line with Mr. Justice Scalia's opinion in Coy, Your Honor, which talks about the historical need for real face-to-face confrontation. And the cases that have dealt with exceptions have been very limited, and according to the authority quoted by the state, they've dealt with, as I tried to say earlier, with child witnesses. There has been, and I think the court is very correct, that not only do you have to examine the mechanics of this, but you also have to examine whether the reason why they want to do it rises to the same level as the state's concern for the welfare of the children. In this case, it's not necessarily clear that the reasons they want all these people to be on Zoom is concerned with anything other than the very health issues, which are not precipitating what Mr. DeGuerin is talking about as it applies to counsel. So on the one hand, the people argue that these people need to be on Zoom because they're scared to come, but that means that Mr. Durst gives up his confrontation right that, if you read Mr. Justice Scalia's opinion, is really in stone. And when, for example, Sandra Day O'Connor expanded Coy a little bit in the context of child witnesses, it was not intended to apply to adults. And just because, Your Honor, we're in this unique situation doesn't mean that we substitute the right of confrontation, again, Your Honor, based on expediency.
Right, okay.
The process problem arises. So I know that we're trying very hard, and you are, Your Honor, to figure out a way to move forward, and we respect that. We know that's your obligation. But that obligation cannot be at the expense of Mr. Durst's confrontation and due process rights.
All right, anything else on the issue? Okay, or on this? And again, I think as to specific witnesses, I do think there must be a justification as to each witness. We can't just paint with broad strokes and say we've got a pandemic, no one can come. I think it really does depend on their circumstances, and as far as your attendance, your circumstances. So I think both sides are urging that I consider the impact of COVID-19 in making decisions here today, and so you do seem to agree there's some overlap on the arguments, but a difference as to how I ought to apply the implications of, for counsel and the implications for witnesses. You're telling me they're the same, and yeah.
If I might add, I didn't mean to interrupt, but if I might add, and go just another step further, Mr. Bain is sincere in saying that he thinks that an electronic image can substitute for personal appearance, and frankly, we greatly disagree with that. There is no substitute for a human being being in the courtroom and having the ability for the jury to judge credibility from that appearance. An electronic image of that person simply will not, it cannot, whether it's high definition or whatever it is, cannot substitute for that. So we're very strongly opposed to that on the mechanics of it. As far as practical efforts in this new courtroom, it applies here to substituting electronic images for personal appearance. We don't think that the court can adequately provide a substitute being in court, and so the jurors and the court and the lawyers can adequately assess the witnesses. They just were very much against it.
So let me ask you a question, Mr. DeGuerin. So you would agree that conditional examinations under some circumstances are admissible, and they are video recordings of direct and cross-examination. Those can
Yes, there's a specific procedure for that. We've agreed to some of the conditional examinations and for other reasons. But where it's an important witness, we just do not agree. So yes, conditional examinations, there is a specific provision for, but I don't think there's a COVID provision in the law or anything that can be read in the law to apply to this completely different situation we have.
So Mr. DeGuerin or Mr. Chestnut, tell me, so does that mean you cannot have a trial? What if someone insists on their speedy trial? That's an important right too. I mean, don't we take...
You're asking Mr. Chestnut, but I think we would rise as one and speak in unison that we cannot have a trial now under these circumstances.
Your Honor, so it's clear. Mr. Durst knows we were asking for a mistrial, knows how long we wanted for the mistrial, knows that he does not want to jeopardize Mr. DeGuerin's health or the rest of us. So although he expressed to you the fact that it's been a long time, as officers of the court, we represent to you that Mr. Durst understands that a delay would be in his best interest and the best interest of his counsel.
All right, but again, I'm really talking about confrontation. I'm just, so by your theory, you couldn't really, there'd be circumstances where you could not possibly confront a witness and therefore a person couldn't be prosecuted.
Well, no, Your Honor. Your Honor, I have a feeling, most respectfully, that we're going to see rulings by courts, appellate and otherwise, about the impact of the pandemic on the right to confrontation. But when I read to you this morning the quote from the Chief Judge of the Southern District of New York, which has the busiest federal docket in the country, she said we can't start trials and you can't do things where people can't look at, you conducted cross-examination in the manner that's been traditional. So in the hundreds of years of our court history, we're asking for, a hiatus until defendants can get treated the way defendants got treated a year ago. and we'll get treated hopefully when there's a vaccine a year from now. But to subject an individual defendant to an unconstitutional trial because there are ways to make it appear constitutional, it doesn't rise, it's not appropriate, Your Honor. It's not a matter of, Your Honor, that we don't think that, for example, if we were fighting over some money in a civil case, that's a whole different ballgame. But when you're talking about the right of confrontation in a special circumstance murder case, it's different.
All right.
And it rises to that constitutional level, and that's not just our opinion, Your Honor. That's the opinion of the NACDL. The opinion of most lawyers that Mr. Ray, Mr. DeGuerin, and not all lawyers that Mr. DeGuerin, Mr. Ray, and I talk to that do what we do.
Okay, well, thank you for...
Nobody wants to be the guinea pig.
Right, all right, thank you. I mean, the NACDL, I respect them also. I don't know that it's authority, nor is an interview with a district judge in a newspaper. I'm not sure that's really the authority I'm looking for, but I think what you...
Please read Justice Scalia's opinion in Coy, Your Honor.
What's that, dissenting? Concurrent.
It's 108 Supreme Court 2798.
Was that cited in the motion? I didn't see
No,
it.
I know you can cite cases. Give me the cite again. 108 counts, Supreme Court.
108 Supreme Court 2798.
2798. Anyway, but here's the thing. We're talking about, and I will look at it, but we're confusing our arguments, and I want to be precise. You're talking, you're talking about whether or not the trial can go forward safely, but the issue we're discussing right now is, can there be remote testimony by persons who the court finds would be vulnerable, in mortal danger should they come here?
Right, and our position is, Your Honor, that mortal danger doesn't trump the confrontation clause.
Your Honor, we're still back. It's a clever... They lost the mistrial motion. They've hijacked the motion we're on back to the mistrial
It
motion.
had nothing to do with the mistrial either. You see, the problem here is with this discussion of, and that's, listen, that's the emotional argument. That's what we're concerned about. We're concerned about health and safety. You can assert that the conditions aren't safe enough, that there isn't enough assurance either generally or for oneself. And I hear both arguments. And then say, thus we move for a mistrial. The second doesn't follow this. Now the argument is that the same argument, but it doesn't trump the right to confrontation.
We feel the direct opposite. It's okay for them to hijack the Constitution because their witnesses are old, but it's not okay for us to want the Constitution because the lawyers are old. We're actually more logical in extending this argument.
There's a lot.
But so it's crystal clear.
Yes.
Unequivocally object to Zoom examination of witnesses in a special circumstances case, regardless of the rationale, other than the one that has been accepted if there was a child witness in this case. That qualified.
All right.
So to make it real clear,
Yeah.
we're objecting on two bases. One is that we should not have, the confrontation is not live, it's an ineffective confrontation to have electronic images of the witnesses. But secondly, the justification for the witnesses not appearing is also justification for if it's too much of a health threat for the witnesses to appear, it's too much of a health threat for the lawyers to appear.
All right, I'll keep that in mind when we decide about, well, I'll keep it in mind. If you have another motion to adjourn, I'll hear it, but you haven't made that motion and it ought to be in writing.
Your Honor, and on this issue, just very briefly,
Yeah.
two things. It's very important, and the court knows the rule. You cannot cite cannot cite authority that is not in your motion and argue it because the other side doesn't have the opportunity. So when the court, so when,
That's why it was in our brief, Mr. Lewin.
that's why I asked.
It's the U.S. Supreme Court, and I know you're always concerned with making sure the record's complete.
Well, so the issue is, again, if you're gonna cite something, I just wanna be able to respond to it. I don't see it as.
We know that Maryland versus Craig controls this. It is Maryland versus Craig that the people must satisfy
Yes.
before I will allow a witness to testify remotely. Apparently, Justice Scalia put it in a way that Mr. Chesnoff believes was very persuasive, and he'd like me to read those words. So
Okay.
I'm going, I took it as a rhetorical
Okay.
plea. So I will, and perhaps there's a different rationale, but I will look at it because he's imploring me to do that. Why shouldn't I?
Your Honor, the second point that counsel made is that they are equating, and we're going to be clear, we are not saying that every witness now, it's not safe for them to come here and that they should testify by Zoom. So by definition, Mr. DeGuerin's point is nonsensical because we've already agreed that we're only talking about out-of-state witnesses who have to fly here on planes. Now, Mr. DeGuerin and Mr. Chesnoff and Mr. Lewis have more than a month right now to get themselves out here. They have a lot of different alternatives to how they want to do that. That is not going to be true with our witnesses. So the idea that Mr. DeGuerin says, well, if you're going to allow any accommodations for witnesses, then that means that we don't have to be out here either, and that means you got to stop the trial. It doesn't make sense. It's not the rationale of any authority that's been cited. It's just plain wrong.
All right, do you have anything else to argue on this point?
No.
I want to make sure that we're clear that we don't think that electronic images will comply with the confrontation clause.
Right. Okay, let's see. I've got to read your case. Let me pull it up. I've got it right here. Do you have a page site, Mr. Chesnoff?
Which case, Your Honor, on Coy?
Yes. Yes,
On which case, Your Honor?
Yes,
I'm sorry,
Coy.
I didn't hear you.
Coy,
Yeah, I can give you the Coy site.
the page site. The page site.
Well, the entire opinion is about the confrontation issue, Your Honor. So it starts at 108 Supreme Court, 2798, and it goes all the way through 2803.
So you're talking about Blackman and Stevens' concurring opinion.
No, those are Blackman wrote a dissenting opinion, Your Honor. I was talking about Scalia's opinion. He wrote the opinion for the court. Scalia wrote the opinion, Your Honor.
Oh, I got the wrong case. So yeah, you told me it was 108 S Court 27.
98.
It's 487 U.S. 1012.
That's better.
Your Honor, this is Kathie Bailey. I'm just pulling up now and I'm looking at the first page on the holdings at least. The appellant's right to face-to-face confrontation was violated since the screen at issue enabled the complaining witness to avoid viewing appellant as they gave their testimony. If that was the concern of the court, certainly we can arrange screens so that
Your Honor, and we wrote about
the appellant.
We wrote about that case at 9 or 10 of our mistrial motion, Your Honor.
All
Right, I
right.
thought we were done with the mistrial motions.
No, he's just saying that's where it's cited, and now he's reviving it on this motion. So again, all right, I know the case. This is the one with the screen blocking the witness.
Yes.
That's different, don't you think?
It's not a TV screen.
Right, it's a privacy screen.
Right, but the history of the confrontation clause and face-to-face, what face-to-face means is what Justice Scalia talked about.
All right, I will
We're
find.
just like ignoring it because we're going to be on television.
Okay, just-
Television doesn't, everything shows that these Zoom, people do not pay attention, facial expressions are lost, but Your Honor has all of that in our pleadings. So it's a judgment call by you, Your Honor, if you think that the Zoom that Mr. Habib is proposing rises to the level of satisfying the confrontation clause. We don't think it does.
I'm reading Justice Scalia's opinion now.
Of all the senses, they'll be able to see the witness, they'll be able to hear the witness. They wouldn't be able to touch the witness, which I doubt they'd be allowed to either. They won't be able to smell the witness. I don't know.
And they wouldn't be able to see any of the body language or any of the other multiple ways that equal judge credibility that would be lost.
There'd be a full image of the witness from whatever can be viewed from the table they're sitting at upward.
All right, I don't want the back and forth dialogue, please. He quotes Richard II. He is one colorful writer.
It's actually Shakespeare.
Right, from Richard II to be precise. All right. It is always more difficult to tell a lie about a person to his face than behind his back. In the former context, even if the lie is told, it will often be told less convincingly. It's a good opinion. Maryland versus Craig governs the case. So, as a general principle, I think that the essence of confrontation is likely preserved and I would only resort to this if it's justified, so the justification must be presented as to each witness. And also I do think that the reference to Penal Code Section 1340 is useful. It's designed by the legislature, it was not designed by a court. It's withstood scrutiny this long. I think it's a good model, but again, we must protect the right to confrontation if its essence is denied by the particular technology or by a lack of justification. I won't allow that testimony. It is witness specific. And now I have what is this? This person is not counsel. So attorney for a third-party witness has lodged a document here.
Doug Oliver's lawyer, Your Honor. Mr. Oliver
He's volunteering for the 1340 procedure.
He is, and he fits the process, fits the requirements the court's given. He's well over 65.
At the time of presentation or reasonable time before presentation, you need to demonstrate to the court that the procedure is justified. All right, next we have stipulations. Counsel did all agree on stipulations number 52 through 56. The court receives and appreciates and accepts those stipulations. I want to talk about our next hearing date. Any other issues that I need to decide first?
Yes, Your Honor, we are concerned. Counsel first brought this up during the May 21st, 2020 conference call, where for the first time they mentioned that Mr. Durst may not be testifying. They now brought it up again today, saying that in essence, they have been put in a position where he cannot testify. Now, if they choose to make that tactical decision, that's their decision. However, I want to be clear that we are more than willing. First of all, we're going to ask, Your Honor, that the defense demonstrate to the court, and it can be ex parte, the efforts that they have made to attempt to prep, quote, Mr. Durst for his testimony. We would add that, again, since they entered the stipulation in December 22nd of 2019, our concern is that this is going to be used as some either attempt to force a mistrial later or to, on appeal, argue how their rights were infringed. We are saying right now, Your Honor, I think the court mentioned this in the call, if the defense needs to have, we're off on Fridays, if they need Fridays to prep him. The court mentioned, again, we're off the record during the conversation, but the court said, and I'm repeating what the court said at the time, defense, if you need to adjourn early on some days to prep Mr. Durst, we'll do that. The court even said that if you need to have a brief recess before Mr. Durst testified to prepare him, that you'll accommodate that. We will also certainly, Your Honor, agree to any reasonable efforts by the defense, but again, it cannot be hollow and it cannot be gamesmanship. They need to actually demonstrate that they've made efforts to resolve this problem. That then brings up, Your Honor, Mr. Milius's email, which relates to the technology that the prosecution wants to use in the case. Now, we sent that to the defense and to the court because it does involve the court agreeing to let us use it, but it also provides the defense with, if they are interested, some very easy ways that they can mitigate the issues that are going to be out there. So our first question is, Your Honor, does the court have any objection? I would turn this over to Mr. Milius with what we are requesting to do for our people's side.
So you did send that email to me. You notified the defense. They were on the email also. We often have emailed so that we could talk about procedures, and it made sense to me. And the policy of this court is to facilitate communication any way we can through electronic means. The example today is allowing counsel to appear by phone, whatever we can do to make this work. I don't think it would be too obtrusive. If it were, then we'd talk about it. And perhaps the defense would like to utilize that procedure as well, or they can reject it out of hand if it, for some reason, it doesn't work. But I think there are other means for communication. We can talk about them, but that's not really. Your question is that permitted? Yes.
Well, remember, the defense response, Your Honor, was not only do they not want to use it themselves, Mr. Chesnoff requested that we be denied the opportunity to utilize it as well.
I see. I didn't realize there was an objection. I thought that the part of the problem was that it was by way of an email, and if anybody objects to communicating privately off the record, that's fine. Mr. Chesnoff, do you have an objection to the people utilizing those procedures to communicate silently with each other during the trial, even though they're 6 feet apart?
Obviously, Your Honor, I'm in the same boat you are. I want to see how it works before I would commit. I'm not going to interfere with methodology that they want to use as a team. That's not my place. But if it creates some kind of an issue impacting the way that the case is presented on Mr. Durst, as it affects Mr. Durst, then I would raise it. But until I actually see it in operation, it would be difficult for me to give an opinion. But like I say, I'm not looking to be obstructing. I'm just telling you that we don't think we have a different role in this than the people do in terms of what we believe is appropriate communication with our client. We all want to be able to talk to Mr. Durst when we want to. We want to be able to be close to him for a lot of reasons. Most importantly, the fact that he's hard of hearing, and it's a lot easier to communicate that way. But on its face, Your Honor, we would have no objection to the the people employing some methodology of communication that they choose. If we see something objectionable, we'll let you know. But we don't want it to apply to us.
Also, I can meet with you on attorney-client matters ex parte, so I could, in the Inglewood Courthouse, meet with you, and we could work out a way for you to communicate with your client. I don't know what will work, but we can at least test possibilities. I'm just making that invitation. I realize.
Thank you. I'll discuss it with the rest of our crew and let you know, Your Honor. Thank you.
Mr. Milius, any problem with that?
No, I have no problem. I would actually volunteer my time to meet with the court, meet with defense if they'd like to see how we plan on implementing it. I have all the time in the world to help them and would love to.
All right, Mr. Milius is willing to cooperate. So that same spirit of cooperation you've shown in reaching these stipulations, perhaps it will extend to accomplishing the trial.
Your Honor, is the court, with the comments that I made regarding the recitation and what we had discussed regarding the defendant's testimony, etc., and regarding, is the court still making the same offers to the defense that it made during our conference call? In other words, that the court will work with them if on Fridays they'll have access, etc.
Absolutely, and whatever I can do to facilitate the visits. It's difficult at the jail, understandably so. There may be problems in the courthouse also, but we can address those problems.
One other issue that relates to this, and I brought it up in my argument, I don't think the defense has done this, but something I certainly would have done if I were Mr. Durst's attorney, is I would be talking to the sheriff's department to find out, can he get his own transport so that there's no one else on that? It's already on a small bus. I'm not sure if he can or not, but I don't think there are going to be a whole lot of trials going on. It might be by himself anyway by that time. I don't know. But
yes, we'll look into that.
Okay, appreciate that, Your Honor.
So the obviously the defense has defense counsel now. 3 defense counsel have submitted medical information showing that they could be vulnerable and that they are 65 years of age or older, 3 of the 4 defense lawyers. But that information was as of June 10. So the age and the underlying conditions are not going to change, but Center for Disease Control and California Public Health recommendations probably will change. They do change rapidly sometimes. I'm going to order counsel to be present in this court July 20 or document why they are not present. And at that point, the burden will be on the defense to prove why the trial should not proceed on July 27. The defense has supplied an expert analysis of the circumstances of trial, some very interesting material and persuasive material. I'm not sure that the South Korean call center was comparable because of it didn't seem there was any social distancing, but of course I want to avoid creating a super spreader event. We won't do that. We're here for you, safe for you. That's the policy of this court. So I'm open to hear more and for you to incorporate material from your mistrial motion so I can consider that. But the burden is on the defense to show why we shouldn't proceed. Now, to the people, if is that date sufficient for the people? If, for example, if I were to be satisfied that I ought to delay longer, I don't know if that would cause a problem for you that I'm setting this on July 20.
Could we go a week earlier, Your Honor? Give us a little more leeway.
Well, let me just add this, Your Honor, and
Yeah.
I'll just present it because there's 2 ways to look at it. Obviously, the closer we are, the better the assessment the court can make.
And we may have a window of opportunity. Let me just interject. There may be a window of opportunity. The safest time may be sooner rather than later. But I do feel that my obligation to the community, not just to the people in the defense, is to maintain public health and maintain an environment that is a safe environment. So saying that, I am open to hear what evidence you may have about safety or lack thereof. The problem with going earlier is I'm not here.
We're up to, the 20th is fine, Your Honor. Can we ask the court this? Because the last information we had is several weeks old. Can the court indicate what the status is with the jurors at this point in time?
So I have intentionally not had dialogue with jurors. We know that they are essentially unlimited in time. We know that some of them are older. We know that some of them have child care issues potentially. I want to choose a time when our jurors feel safe, when we maximize our number of jurors and that they feel safe and that they are safe. So that is also, again, I do not want to have to go through another jury selection process, so I think it's very, very important that we should shepherd this. Sooner may or may not be better. So and if we need to wait, we'll wait. But
Also, Your Honor, this is David Chesnoff.
Yes.
What does the court envision as the methodology to get the true feelings of the jurors?
They will be, when they come in, they will tell us if they have problems.
Will it be done by a voir dire?
We will, in a sense, we'll inquire who might have problems. I expect we might spend a couple of days talking to jurors about their problems and if they can be reconciled. I don't know. It depends on the circumstances. But to get back to my earlier point, I don't want to engage in dialogue with jurors when you are not present. So we have simply sent them the message from this court, which you'll read in the minutes. It's the Cal-Crim admonitions about avoiding media and not talking about the case. So we don't know the status of the jurors.
Your Honor, am I correct though? The court had said when we had spoken when we had spoken.
Yes.
With all respect, I think July the 20th or the 27th is way too early. Given that we're on the rise in the incidence of coronavirus.
Mr. DeGuerin, your feelings, I care about your feelings, but I really am going to respond to evidence. Okay? So present evidence.
Can I just let me follow up on that? You're saying we're going to have to be there on the 20th personally, even if our doctors are saying we can't come?
No, Mr. Ray. Good morning. Good to hear your voice.
Good morning.
No, just say why, you justify why you are not here. And you've given me the reason why you're not here today. I accept that. I need you to renew that for our next meeting.
So, Your Honor,
when is the jurors order going to be ordered for 27th?
That's Mr. Ray. Just if you'll speak before, give your name before you speak, because Rona...
Don Ray. Are the jurors coming in on the 27th?
They're ordered on the 27th, unless I give them a different date, but they expect to be here on the 27th.
Your Honor, the question...
Dick DeGuerin, wouldn't it be wiser to inquire of the jurors before you force them to come in? You're going to...
Your Honor, this is Mr. Chesnoff, so I understand this. If we give you the same kind of medical evidence and whatever else we think is appropriate, statistics, science, you will consider that on the 20th, and that will impact whether you decide to actually have them come on the 27th. Is that correct?
Yes, that is exactly correct. And by the way, one other thing.
On the 20th?
We'll be here on the. We can be here on the. Well, let's see. That's interesting. We can't. We don't have room for all of you here on, but we do have room in Inglewood. I'll get back to you on that. Tentatively, we'll come here. But here's the thing, it's not just your doctor's assessment of your condition, it is also what are the public health advisements current for that time. In other words, CDC, all right?
Yes, like for example, Your Honor, while we were on the call, we read that Governor Newsom just posted that COVID droplets can spread to up to 26 feet. So that kind of information, correct?
Well, not from Governor Newsom, though I admire him. No, from whoever, whatever his source was. I think that was justification for the mask order, and that's why we do enforce masks at all times in our court. But yes, of course, and I don't mean to discount the material, though I have one concern about the South Korean example. Otherwise, I do think it was a useful information, and you can incorporate it by reference.
Your Honor, two things then. At this point in time, the last time the court advised us, there was only one juror who had responded that they had any issue. Is that still the same? There's no update on that, is that correct?
That's all I've heard.
Okay, and the second issue is that counsel seems to be, in their questioning, they seem to be of the impression, as I listened to it, that, well, the court might just grant their mistrial motion on the 20th.
It's not a mistrial motion. If the defense moves to adjourn, then I will. If you don't, then I guess I go forward. And if you feel it's not safe and the people are willing to go forward, it would be your motion to adjourn.
And then at that point in time...
Or to continue the adjourn, we're adjourned now.
Right, but the court isn't saying, I just want to be, because I'm going to get this question from on my side. The court isn't saying that if you get some notes from the defense, that the court is automatically going to accept that and say, okay, we're not starting. In other words...
We'll have a hearing on the 20th.
Yeah, and we'll argue it both ways. And then finally, the last thing...
You may accept what they're supplying.
Sure, yes.
Go ahead.
Yeah, the last issue, Your Honor, is that obviously there have been a lot of statements made by the defense regarding the status of COVID, etc. I assume what the court is also going to be looking at is not just who's getting it, but what is the situation with the hospitals? What are they recommending? Are people getting, what's the level of sickness? In other words, the court's going to look at all of the information. And then finally, Your Honor, and I would assume that this is the case, is that if we have the Chief Justice of the Cal Supreme Court, we have the presiding judge of Los Angeles County, and they are saying, you know what, courts are open, then it's going to end up being, I would expect, an uphill battle for the defense to simply say, well, I know it's been judged that everybody can come in, but in our particular circumstances, because we're over 65 or whatever it might be, we can't come in. In other words,
I can hear that argument, yes, because just because the courts are open doesn't mean that they're open, that it's safe for people to come
It's
here.
an argument for your conditional witnesses.
but
They're over 65 and they're afraid to come.
Okay, well, so Mr. Chesnoff is making an interesting point, and that is both sides have relied on the safety of persons 65 and older. So it's all very interesting, but I will save it for July 20 because there's no motion on the table to adjourn.
great.
A motion to adjourn is the only way I would postpone the case. And then upon a showing such as I have described.
Right. But the court's position where it sits today is in essence, we're restarting the trial. It's a question of not if, but when.
That's true. There's no basis for a mistrial. If you had, there are scenarios that require a mistrial. This is not one of them. The justification has not been shown for a mistrial.
And the court is not suggesting that if on July 20th we're not ready to start, then that means a mistrial. In other words, Your Honor.
Right. It does not mean a mistrial. That does not mean a mistrial either. The question on the 20th, I mean, they can file a motion for a mistrial if they want, but the issue really is going to be adjournment. I think it would be probably futile, but I won't say never, but I think they've exhausted the arguments. It's quite a good argument, but it's not enough for, it's the best argument you can make under the facts for a mistrial, but it's not supported. And that's the ruling.
Our final thing is the court had previously ruled, I wasn't sure it was on the record or not, but the court had agreed that we could videotape our witnesses, so we will have a camera in here when we end up restarting, not in here, but in Inglewood.
We're gonna need a camera because the whole courtroom will be occupied by jurors, and there are very few seats for the public, so I think I do have to allow a camera.
Okay, thank you, Your Honor.
Your Honor, if we met in Inglewood on July 20th, we could demo a teleconferencing Zoom if you'd like.
I will contact counsel if the hearing is to be in Inglewood.
And Your Honor, is that gonna be 9 or 10? We can do either, but I thought it was 10 today. I actually missed the court. The court responded 9, and but for Mr. Abramson, I would have been here at 10.
Thank you, Mr. Abramson.
So, what time are we on the 20th, Your Honor?
I expect we should do it at 9 o'clock.
Okay, thank you, Your Honor.
If your client's 977B waiver was specific as to this hearing, so if for some reason you feel he ought not be present or he wants to waive his presence, I believe I will need a new 977B waiver, or I'll leave it in your discretion to use the 977B waiver in the form described in the penal code. That would be more flexible for you. Are you on the phone, counsel?
Yes, I understand.
That's fine, Your Honor.
Okay, up to you. All right, then we're anything else from the defense?
One final question, the 27th, when the jury comes in, are we to expect witnesses also?
As a practical matter, I believe that when jurors come in, there are certainly going to be some people who have hardships, and I want to hear them out. It might take a day or two, so I don't expect witnesses on that first day. Oh, also, it's occurred to me that because of the delay, I ought to allow an opening statement by each side without any audiovisual, just because I want to minimize it, but I would allow a brief opening remarks from the people and from the defense, or you could reserve it. Defense can reserve it.
And how long, Your Honor, are those remarks?
An hour.
Okay.
An hour,
Your
that's
Honor,
all.
you think you will ask jurors questions about whether or not they did view anything?
Jurors have an obligation to tell me if they did.
Sua sponte?
Sua sponte.
Your Honor, my call was breaking up on my heard. Are we doing the audio review presentation on the Zoom on the 20th or some earlier date?
20th.
We can address the 20th. Okay. Thank you.
Well, no, I've been given a good reason why we ought to meet here unless I tell you otherwise. Department 81, unless I tell you otherwise, just because of a small logistical issue. But you can demonstrate it just as well.
Video presentation earlier in Inglewood. It's important to do it in Inglewood. And we could do it the week before. That would give us time to resolve any deficiencies that you observe. We need to work anything out. It could be any date between now and any date that's available.
You're breaking up.
Yeah. No, previous It's my first day back. Yeah, we tried the 17th. How about the 17th instead of the 20th? The 17th instead of the. We can do it in Inglewood. We believe we can do it in Inglewood on the 17th.
Okay, that's the 20th.
Is that good for all counsel? Friday, July 17th?
Yes, Your Honor, that means
Your Honor,
that...
this is Mr. Chesnoff. We'll try to figure out, one, what our position is vis-a-vis the 20th. Perhaps we can do that before the 17th, if that's understandable in the circumstances. In other words, if we, and then secondly, we would probably have to have somebody as an observer for us.
No, I think he's saying that it's going to just move to the 17th, I think.
For everything?
Yeah, everything to the 7th, move everything to the 17th and count,
That's fine with us, Your Honor.
the 20th is a problem, so we'll do it on the 17th. And,
In Inglewood.
in Inglewood, yes. Inglewood 1.
This is Don Ray again, but we're still filing in 81, correct?
Yes, we're here until that day. We'll be here. We'll file it here. And, I think that's all.
Thank you, Your Honor.
All right, we're adjourned until July 17th.
Your bell did not
The
survive.
bell, should I ring the bell? No, the bell's
I don't know.
why not?
Oh, there it is.
All right, Department 81 is adjourned.